This episode of the Restoration Today podcast is brought to you by Actionable Insights. Actionable Insights is the restoration industry's leading educational nonprofit, helping contractors and carriers settle claims on the daily. Go to getinsights.org. Hey there, thanks for checking out this episode of the Restoration Today podcast. Today, I'm very excited to be joined by the restoration lawyer, Ed Cross, Uncle Ed, whatever you prefer to call him, whatever you know him by. He's a big name in the industry. He knows a lot about a lot of things. So today we're going to mainly be talking about assignments of benefits, but we're also recording this just after Hurricane Ida hit the Gulf Coast. So we wanted to jump in and talk a little bit first about some tips that Ed has on getting paid if you're out doing cat work right now. Hi, Ed.
Hi, how are you, Michelle?
I'm good.
Thank you so much for having me on today. You're doing a fantastic job with CNR. Congratulations on taking it over, ladies and gentlemen. Michelle Blevins is refreshing this legacy publication, is doing a fantastic job, and it's really going to be a game changer for the industry. So kudos to you for that.
Thank you.
So you want to hear a little bit about collections. Yeah, a lot of people come into the world of cat losses kind of underprepared, and they go home empty-handed and pretty sad in the process. There's a lot of interesting discussions going on online right now. Do you wait to get invited into the theater of action there, or do you just go in there and start prospecting for work? And we want to be careful about that because it's hard to get paid. And is there money? Who's going to pay? When are they going to pay? Do they really have the money to pay? And one way that contractors find themselves in an unpleasant surprise is when they find out that their customer doesn't actually have flood insurance. They may have regular old wind and fire and water damage insurance, but flood coverage may be excluded under the terms of their policy. We want to make sure that we comply with all of the state's licensing laws. And different states have different types of contractors license laws. The state of Texas, for example, does not have a state general contractor's license. It's handled at the local level, and the municipalities handle it differently. A lot of people think, well, I'm just going to do work under someone else's license. Well, it's not that simple. Licenses aren't something that you pass around like cheeseburgers. Okay. As a general rule in most states, to be working under someone's license, you need to be an employee of that entity, or you need to be a subcontractor who holds the license that's necessary to do that sort of work. And there's a rampant problem in the construction industry, not so much with restorers, but elsewhere, where people think, oh, I'm just going to do, this job under my cousin Ricky's contractor's license. Not so fast. We want to make sure that we are complying with the local laws regarding whether or not there's a right to cancel for residential projects. And sometimes those rights will be longer where there is a state of emergency that's been declared by a public entity. We want to make sure we have a signature first from somebody who is financially responsible and agreeing to pay. And of course, I always want to have a fixed price contract anytime that I can get it, as opposed to a time and materials contract. What? How are we going to get a fixed price contract for emergency service, Uncle Ed? Well, Uncle Ed is going to tell you. We break the service down into segments, into phases, and you may not know what it's going to take to return the property to its pre-loss condition. But if you know enough about how many air movers and dehumidifiers to bring in on the first day, you can at least give a price for the first 24 or 48 hours of the work. Maybe it's half a dozen air movers, a dehu, and 10 labor hours. You put that into a fixed price contract without committing to bring the property back to its pre-loss condition. And you tell the customer, we're going to come back with a change order. This is the first phase. We want to get you started, and then we'll come back and figure out what the prices are. So we have found over the years that there are 10 basic steps that help contractors get paid the most, or 10 things in my practice that have worked out the best. One is having a strong contract. Another one is having good, solid documentation that explains the who, what, where, when, and why of the job so that a third party can reconstruct the key events of the project long after the fact without having any access to the eyewitnesses. The third is to stay in the loop with the insurance adjuster so you know what communications are taking place. I think it's a good idea to have policyholders sign an insurance information authorization and release that instructs the insurance company to release information to the contractor. It waives the right of privacy on behalf of the customer, and it's an irrevocable document, so they can't take it back. And hopefully you can persuade your policyholder customer to allow you to be present in all of the meetings with the adjuster, to be CC'd on the emails so that you're aware of what's happening, what discussions are taking place regarding the price, regarding the scope. And in the event that the adjuster might be inclined to steer your work to one of your competitors, you can be an eyewitness to that. Another step in avoiding collections problems is to fight back against the attempts to use standardized price lists like Xactimate as global pricing. That's not what those price lists were intended to do. Speaking of price lists, we want to make our own price lists. My buddy Ben Justison, for example, has a great course on how to come up with your own price list. Very, very important information. Pricing is getting more difficult and complex all the time, and we really need to get educated on the technicalities of how to use Xactimate and the other pricing platforms that are out there. When we're doing CAT work, particularly commercial work, we want to be prepared to fight back against problems that arise with third-party consultants. And the Restoration Industry Association has put out a series of position statements as to how third-party consultants can stay in their lanes. And prominent third-party consultants were involved in providing feedback and input into those position statements. They're sensible, they're logical, they're reasonable, they are available for RIA members only at restorationindustry.org, and it's a great way to help your collections on that end. You want to make sure that mortgage companies don't hold your money hostage. And the way I do that is by not releasing the original check to them, but by sending them a photocopy of the check together with a contract that they sign that says that they're going to endorse it and send it right back. And once you let go of the cash, well, she who holds the cash holds the power. And I'd be very reluctant to let a check go over to a mortgage company if you can possibly avoid that. How are you going to get your hands on the check? Well, hopefully you'll have an assignment of insurance rights and a direction to pay so your name gets on there. Another important part of the collections process is determining the proper rhythm and pace for escalation of your collection efforts. We don't want to go too fast and too hard, but we don't want to go too slow either. Older collections are a lot harder to collect on, and we don't want people to think that we have given up on collection. The squeaky wheel gets the grease. We want to make proper use of mechanics liens and really understand the technical rules with those. If you've never done a mechanics lien before, don't experiment. Get some professional help with that, because if you miss the deadlines or you fail to dot an I or cross a T, the rules are very, very strict. Mechanics liens put a cloud on title to people's property, and it needs to be done properly. Last but not least, of course, we want to decide when and whom and how to file a lawsuit if that should be necessary. And there's a bunch of different factors to consider with that. And a lot of restoration contractors recently are filing lawsuits for the purpose of trying to discourage insurance companies from engaging in ongoing bad acts. If there's a repeated problem with a given insurance company, it can file a lawsuit against them to try to set a precedent so they won't do that again in the future. Really long answer to a very short question. I apologize. You can edit out most of that after I said hello.
No, it was perfect. That was a good answer. Now they know how to get paid if they're doing CAT work. It's awesome. Okay, so going back to your statement on your comment on assignments of benefits or AOBs, you actually have coined the term, a little more friendly term, assignment of insurance rights. So can you define a little bit what that means?
Yeah, so originally back decades ago when I first started doing assignments, they were just assignments of benefits, meaning assignments of the money that's going to come from the insurance policy. But policyholders have more rights under the policy than just the right to recover money. They have the right, for example, to go to appraisal. They have the right to sue the insurance company for breach of contract if it's breached. They have the right in egregious cases to sue the insurance company for bad faith breach of contract, or in some jurisdictions, insurance bad faith, which is a tort. Well, those are other rights that go beyond the benefits. So I'm no longer calling mine assignments of benefits anymore. I've got an entire document that's dedicated just to the assignment, and it includes all of these multiple rights. So I don't call it assignment of benefits anymore. I call it an assignment of insurance rights. It includes an assignment of benefits along with the right to go to appraisal and the right to sue the insurance company.
Okay. All right. So let's get a myth or belief out of the way that AOBs are bad because of what happened in Florida. So why is Florida a bad example of assignment of benefits?
The state of Florida had a practice where they were very liberally handing out attorney's fees to contractors who filed lawsuits holding assignments of benefits. And it created a bad situation because the courts there were ruling that any time the insurance company made a payment to those contractors, then they were looking at the contractor as though they were like a prevailing party in those cases and were entitled to the recovery of attorney's fees, even though the insurance company had not necessarily breached a contract or acted in bad faith. And that encouraged some to start filing lawsuits very early on after sending an invoice, even before the insurance company's payment obligation had arisen. And so that led to a wild explosion of lawsuits. Tens of thousands of lawsuits got filed there, excuse me. And that situation didn't take place anywhere else. There aren't other states who handle attorney's fees in that way. Well, of course, the insurance industry fought back hard against that. Their lobby is very, very powerful, not surprisingly. And they managed to get a very extreme law passed that goes in the opposite direction and imposes a lot of severe penalties on anybody in the state of Florida who holds an assignment of benefits. For example, you waive the right to recover money from your customer. I don't like that. And I suggest to people that they think twice before using an assignment in Florida.
Okay. All right. So contractors that have never used assignment of insurance rights, how do they get started? How do they get involved in using them? What's the right process? Where do they find the right documents? Make sure they're doing it the right way.
So the answer to that question is going to be the same as my answer to most questions, which is to join the Restoration Industry Association at restorationindustry.org. There's an enormous plethora of valuable resources that are available there for RIA members only, and it will help them in all different aspects of their business, whether it's with pricing or collections or dealing with consultants, on and on. We've created a tremendous amount of material there. And the one that I'm referring to now is RIA's 50-state reference guide for assignments of benefits and insurance bad faith. We had a team of lawyers working anonymously, very, very generously donating their time to create this very large collection of legal information that is a roadmap that restorers can use together with their lawyers to come up with an assignment of benefits strategy that works best for them. Assignments of benefits are not necessarily for everyone. They don't fix all problems, but the main problems that they help with are they allow the restoration contractor to step into the shoes of the policyholder and enforce the insurance company's duty to pay fair market value for the loss. And one of the main problems that restorers complain to me about is insurance companies lowballing and trying to use standardized pricing like global pricing. Well, the contractor doesn't have a direct legal right to stop them from doing that unless they get an assignment. Now, If you are the owner of a franchise, you may have some limitations in your franchise agreement as to what kinds of assignments you can get and when you can get them. A lot of the major franchises allow an assignment of payment, for example, but not an assignment of the right to sue the insurance company. So take a hard look at that and figure out exactly what you are and are not allowed to do. You want to take a look at your TPA agreements. If you are on a TPA program or a preferred vendor program, there may be some limitations in there as well. And you don't want to use assignments on projects that are running through those programs to the extent that the assignments would be limited. So you have a look at your state's law as it's spelled out in the RIA 50 state reference guide. And you take that to your local lawyer, you discuss the pros and cons, and come up with a strategy that suits the particular needs of your business. If you have a problem with policyholders running off with insurance proceeds, you are probably going to benefit by having an assignment of insurance rights or an assignment of benefits, because if the insurance company has been put on timely notice of the fact that you're the owner of that part of the claim, but they send the check to the policyholder without your name on it, you can force the insurance company to pay a second time. This is very powerful. I've done this a number of times against a number of major insurance companies. We have forced them to pay a second time because the policyholder ran off to Hawaii with the money or used the money to pay off the mortgage. So these are important considerations, and the RIA provides really good guidance on how to proceed with those.
Do contractors who use AOBs or assignment of insurance rights, do they ever run into pushback from either the insured or the carrier or an adjuster before it's even signed? And if so, how can they, what does that conversation look like to try to explain and get that in place?
So I have had clients using assignments on thousands of different claims over the last 20 years. It's extremely rare that a customer or a policyholder will object to it. In the limited circumstances where they do, I think the best way to respond to the question is to simply analogize to the doctor-patient example. If you have health insurance and you go to the doctor and the doctor is on your program, you sign an assignment of benefits. And a lot of them, I just signed one the other day with a doctor. It also included an assignment of the right to sue my health insurance company. I was like, have at it, you guys. I got no problem with
the
that.
one person who actually reads all that stuff. Sorry, the rest of us are like,
yeah,
sure.
I saw it. It's like, oh, check out this assignment. This is a very normal thing. Assignments are a very common part of business and commerce in this country. Most mergers and acquisitions involve assignments. And, when I go to the doctor and I assign the right to the doctor is able to bill my health insurance company directly. It saves me the hassle of chasing the insurance company for the money. And so I just wait for the doctor's adjusted bill to come in, and the insurance company has already paid part of it. And then I got the patient responsibility on there. It's a good way to go. I see it as a convenience for me. So the doctor-patient analogy, I think, is the best way to sell it if somebody questions it, but usually they won't.
Okay. All right. Yeah, that's good to know. That is such a good example. I've heard you give that before, and it makes perfect sense. Okay. So can you give a real world example? I know you can't talk specifics about any of your clients or anything, but kind of a specific example of when assignments have really helped a contractor get paid faster and in full.
Yeah. So the common situation, Michelle, is where the contractor writes an estimate for $10,000, and then the adjuster comes in with an estimate for $7,000 and then refuses to talk to the contractor anymore. If the contractor is an owner of that part of the insurance claim, the insurance company no longer has the ability or the right to slam the door in the face of the restoration contractor, does not have the ability to say, hey, you're required to pay fair market value here, and here's the evidence of fair market value, and to really put pressure on the insurance company. It's not that we go into these intending to file lawsuits. Like I said, my clients have used thousands and thousands of assignments on different projects over the last 20 years. And the number of instances where we filed lawsuits on those, very, very small. It's a tiny fraction, much less than 1% of the time do we ever file lawsuits on those. So, the policyholders can understand that this is a benefit, and the contractors are able to get in there and have a real world discussion with the insurance company about what the fair market value really should be without the insurance company having the ability to refuse to speak to them anymore.
Okay. All right. Let's shift over and talk about the RIA and the AGA and all the things. So you've mentioned the RIA and the AGA and resources for restorers a few times in here. And I think something that's important for people to know is the RIA has come a long way just in the last 2 years alone. I mean, it's always been a good association. There have obviously been some ebbs and flows and ups and downs, but the AGA alone has brought, don't smile when I say that, has brought some amazing resources into the industry. And that's it's only getting going. I mean, there's still so much to be done. So much work being done by you, the other volunteers, task forces, all of it. So tell us a little bit more about the AGA and some of the initiatives on the plate right now that's coming.
The RIA's Advocacy and Government Affairs Committee exists for the purpose of helping to level the playing field legally and financially for restoration contractors. The insurance apparatus is strong, it's organized, and it's well funded. And what I've seen in the last 25 years is a gradual erosion of the contractors' rights to get paid and the ability to get a fair shake in the claims settlement process. And this happens on many different levels. We talked about standardized pricing and third-party consultants. Those are two important areas. There's a lot of issues and concerns that contractors have about being on managed repair programs, working with TPAs. And it was time for the association and the industry to unite to address these problems. So we formed committees, subcommittees, and task forces to deal with the individual issues and to come up with things such as position papers. These are peer-reviewed consensus statements created by teams of experts. And we put out position papers regarding third-party administrators, third-party consultants, and pricing. We're working on one now. I'm writing the first draft of a pricing paper that deals with the use of new construction pricing for restoration. This is something that has become a thorn in the side of a lot of restorers lately. They'll get their invoices or their estimates kicked back to them by an insurance company that says, okay, because this was torn down to the sticks, we want to use new construction pricing for it. And the problem is there's some arbitrary adjustments in there that are not necessarily appropriate and are not necessarily fair. So we've got a position statement that's going to be coming out on that. We are very deeply involved in research and analysis regarding the wonderful topic of overhead and profit. This is something that has been an ongoing sore spot for everybody in the whole ecosystem for a long time. We definitely need to see some changes there. And I think that RIA will be leading the charge in that regard. And then we have to keep our eyes out for legislation. As more and more contractors across the country start to use assignments, for example, there is a possibility that some states may try to pass some legislation to curtail those rights. And we want to be present for that. We want to monitor proposed legislation as it comes along. We did this not long ago. A bill came up on the state of Idaho regarding assignments, and thankfully that did not pass. And we just want to make sure that the legislatures hear both sides of the story, because before now, there's been no representation by the restoration industry. And these, do you have flies in there?
Yes, there's
are you okay?
That was hitting my face. Gosh, okay.
Yeah, well, I've got like a strobe light effect going on here. It's my my disco lighting effect. Anyway. We're watching legislation as it comes along and want to be prepared to address those issues as they come up. But this requires people and it requires money. And so we encourage everybody to get involved, to volunteer, to get on to a task force. And you can contact RIA's Chief Executive Officer, Christy Cohen. The website again is restorationindustry.org. And it takes investments as well. And we hope everybody will chip in what they can. It doesn't have to be an enormous amount of money. Contractors have suggested a guideline investment of $100 per $1 million in annual revenue. So if a company's doing $5 million a year in business, this suggested investment is $500. We think that's affordable. We're calling it an investment. It's not a donation. There's an expectation there will be a return on this investment. And we've seen the needle move in a number of ways. So that's real. This is not a pipe dream. Yes, the insurance apparatus has more people and more money than we do, but we can fight things out in the court of public opinion. And we have a lot of power. We underestimate our own power. One estimate is that the property damage restoration industry in the United States is a $200 billion a year industry. I know for sure from reliable sources, it's at least 100 billion, maybe as high as 200 billion. And with stuff that's happening right now, who knows, maybe it'll go above that. So there's a lot of power there, but there's not as much unity as we need. And now is the time. We hope everybody will join the movement.
Yes, join the movement. And for anybody who does want to get involved and you can't find Christy's contact information, Ed or I can definitely steer you in the right direction as well. So you can reach out to either of us as well. Sorry, Ed.
Christy's awesome.
Christy is awesome. So yes.
What a great leader.
Yes, she is awesome. Okay. Do you want to tease about your November, December issue article at all? Ed is going to have an article in every issue of CNR now through 2022 and hopefully way into the
forever until I die.
Forever.
The next article is going to warn restoration contractors to be careful with waivers and releases. This is particularly timely when we're talking about cat losses and stabilization and some of these new issues. There's a temptation to cut corners when restoration contractors get onto projects, and there's a tendency to assume that they can just get a release of liability for everything. Can't get a release of liability for everything. There are certain legal guidelines that need to be followed before a court will actually enforce a waiver or a release of liability. We're going to explore those, lay some of those out. Releases and waivers, they need to be conspicuous. They need to be fair. They need to be rational. And we don't want to just put into all of our contracts, we're not required to comply with the standard of care. That would set a bad precedent and subject ourselves to legal liability. Just because we write something in a contract that says we're not liable for it does not necessarily make it so.
Love it. Okay. Anything else you want to add before we wrap it up?
I just think you're doing a heck of a job. Keep up the good work, Michelle. Kudos.
Thank you. Thank you for your support. I appreciate it very much. And the industry has been great so far. So I'm excited to see where it goes.
For more Restoration Today, visit our website, cnrmagazine.com, or find us wherever you get your favorite podcasts.